My name is Ingrid. I am 31 years old, and I was sitting on an Amtrak train to Richmond when my husband sent me the most insulting text message I have ever received in my life. Before I tell you what happened next, drop a comment letting me know where you're watching from, and if you've ever had someone underestimate you so completely that it came back to destroy them, hit like and subscribe, because this one is for you. The train was half empty on a Tuesday morning. I had the window seat which I needed, because I required something solid to lean against while I read the message twice, to make sure I had understood it correctly. Sign the 15,000. My lawyer files Monday if you don't embarrass yourself trying to fight this. $15,000, 7 years of marriage. I pressed my forehead briefly against the cold glass, and watched the Virginia countryside dissolve into gray-green blur, and tried to remember how to breathe. I am a licensed estate and property appraiser. My entire career is built on determining the exact defensible court-admissible value of things that people try very hard to underreport. I do it for banks. I do it for probate proceedings. I have sat across conference tables from attorneys who spent their mornings constructing elaborate fictions about what property is worth, and I have handed judges documentation that dismantled those fictions line by line. My husband knew this. He had watched me do it for 7 years, which meant his offer of $15,000 was not a negotiation, it was a message. The Shenandoah Valley cabin alone appraised at $280,000. My late father-in-law's antique watch collection, which he had specifically named me in his will to receive, added another 40, and those were the assets I could see clearly. What I couldn't see yet, what I had only begun to trace in the 6 weeks since my husband filed, was the shape of everything he'd tried to move before I started looking. I opened my laptop and connected to the train's Wi-Fi. 3 weeks before filing for divorce, my husband had transferred the cabin deed to a Delaware LLC called Cedarline Property Holdings. He had not told me. He had not asked me. He had simply reached into our shared financial life and removed $280,000 from it, the way you remove a book from a shelf when you expect no one is watching. He forgot what I do for a living. I was deep in the Delaware Secretary of State's Public Business Registry, cross-referencing the LLC's registered agent against my husband's contractor license number, when I heard a sharp sound from the aisle seat beside me. The elderly man who had settled in at Charlottesville had been reading quietly, a thick sheaf of documents, occasionally making notes in the margins with a mechanical pencil. I had registered him the way you register anyone on a train. Gray suit, wooden cane propped against the armrest, reading glasses low on his nose. He looked like a retired professor heading to a faculty lunch. But now his hand was pressed flat against his chest and his face had gone the color of old paper. I shut my laptop without thinking. "Sir, are you all right?" He shook his head slightly and the folder slipped from his lap. Papers scattered across both our seats and into the aisle. Several passengers glanced over. Nobody moved to help. I pressed the flight attendant call button, the Amtrak equivalent, and steadied his arm. His skin was cold and clammy. I recognized the look immediately from 2 years of caring for my father-in-law, who had been diabetic until the morning he died. "Do you have glucose tablets, candy, anything sweet?" He managed to point to his coat pocket. There was a small roll of glucose tablets. I helped him get 2 into his mouth and flagged the attendant for orange juice. Within 5 minutes, the color had begun to return to his face. His breathing slowed and steadied. "I apologize," he said. His voice, once he had it back, was quieter than I expected, measured and deliberate, the voice of someone accustomed to choosing words carefully. "I thought I had managed it this morning." "You're all right now," I said, "just rest." While he recovered, I gathered his scattered papers from the floor. I couldn't help reading them. That reflex has been hardwired in me for so long I've stopped apologizing for it. My eyes catch numbers the way other people catch typos. The document on top was a formal estate appraisal for a residential property in Henrico County. Standard enough? Except that whoever had prepared it had applied a depreciation schedule using 2021 comparable sales data. The Virginia residential market had moved significantly in the years since. The error was subtle, easy to overlook if you weren't watching for it. The effect on the bottom line was not subtle at all. The property was being undervalued by approximately $62,000. I stacked his papers neatly and set the folder on his tray table, then I paused. "I'm sorry to intrude," I said, "but I'm a licensed property appraiser. Page 4 of this estate valuation, the depreciation schedule is using 2021 comp data. Current figures would push the assessed value up by at least 60,000, possibly more." He looked at the folder, then he looked at me. He took the document, turned to page 4, and read the section I'd indicated. His expressions changed. Not dramatically, but the way a person's face changes when they realize something important has just been caught. "I had 2 certified appraisers review this," he said quietly. "It's an easy error to miss if you're not watching the comp dates closely," I said. "I watch the comp dates." He extended his hand. "Morton, retired, heading down to see some old students." I shook it. "Ingrid, nice to meet you, Morton." The conductor announced our approach into Richmond. I was sliding my laptop into its bag when my phone buzzed. My college roommate had sent a screenshot, a social media post from a public account. Jade, my husband's 23-year-old office manager, who had been posting about their relationship for months. In this particular post, she was at a rooftop restaurant, hand raised in a toast. The caption was something about new beginnings. I wasn't reading the caption. I was looking at the necklace. My mother had worn a small gold locket every day of my childhood, and every day I knew her as an adult. Inside it was a photograph. The last one taken of the 2 of us together, 6 weeks before she died of cancer 3 years ago. She had pressed it into my hand on the last morning I saw her conscious. She said it was the most important thing she owned. I had kept it in a cedar box on my dresser. I had not worn it because I was afraid of losing it. The box was still there the week my husband filed for divorce. 2 days later it was gone. Jade was wearing my mother's locket in a photograph with a warm filter that made the gold look beautiful, and she had no idea what was inside it or what it cost me to look at it on someone else's neck. I set my phone face down on the seat. I took one breath, then I picked it up and texted my attorney. "File a police report, stolen personal property, the necklace in the attached photo. I'll explain everything when I land." Morton was watching me. He had the patience of someone who had spent decades listening before speaking. "Bad news?" he asked. "My husband gave away something that wasn't his to give," I said. My voice came out steadier than I expected. "It belonged to my mother." He was quiet for a moment. "I'm sorry," he said, and the way he said it meant he understood the specific weight of that kind of loss. The conference room at Sterling Holt's law firm was designed to make you feel small. My husband was already there when I arrived, leaning back with his arms crossed, and the particular expression he wore whenever he believed a situation was already resolved in his favor. His attorney, Sterling Holt, who played golf with the judge assigned to our case and made no effort to pretend otherwise, sat beside him. I placed my appraisal binder on the table, tabbed sections, authenticated source documents, a single-page summary of Cedar Line Property Holdings asset movement on top. Sterling barely glanced at it. 15,000, he said pleasantly. "My client is being generous. Without legal representation, you're walking into that estate hearing tomorrow and losing on every count. Judge Alford and I understand each other. Sign today, or my client withdraws the offer entirely and you cover our legal fees when we're done." My husband smiled. He looked very comfortable. I looked at the check on the table, then I looked at my husband. I picked up my binder and left. In the elevator, a text arrived from a number I didn't recognize. "I've reviewed what you described. The LLC transfer has federal implications. Cafe Minerva near the courthouse, 7 a.m. I hadn't given Morton any documents. I had mentioned the cabin and the LLC in passing on the train. He had seen my laptop screen when I gathered his papers. I typed back, "I'll be there." Morton was already in the corner booth when I arrived at 7. He was wearing a dark suit, and without the train's fluorescent light, he looked different, quieter and sharper at the same time, the way certain buildings look completely different depending on the angle you approach from. I told him everything: the LLC, the deed transfer, the watch collection, the will contest, Sterling's threat about Judge Alford. He listened without interrupting once. When I finished, he slid a single document across the table. "Read the highlighted section." It was a federal appellate ruling addressing the fruit of the poisonous tree doctrine in the context of marital asset concealment. The highlighted passage established a clear precedent. The expectation of marital privacy in a business workspace is nullified when that workspace is actively used to conceal assets from a spouse in a dissolution proceeding. Every document in my binder had come from public records, the Delaware Secretary of State's Registry, Virginia's property database, federal Schedule C filings I had co-signed for years. Nothing required a subpoena. Sterling will argue your evidence is tainted, Morton said. Everything in that binder is public record, I said. Exactly. If he claims otherwise, he is misrepresenting public record to a sitting judge. Morton folded his hands, which brings me to the other matter. Sterling Holt has practiced in Virginia courts for 19 years. Judge Alford has been on that bench for 11. I'm familiar with the nature of their relationship. Something in his voice made me set down my coffee. Morton, I said carefully, who are you? He smiled, the same measured smile from the train. I told you, retired, heading to see some old students. He picked up his cup, several of whom work in that courthouse. The estate hearing was at 9. I arrived at 8:45. My husband and Sterling were already in the hallway. Jade stood beside them in a pale blue dress, wearing my mother's locket. My mother-in-law, a small iron-haired woman who had tolerated me throughout the marriage and despised me since the filing, spoke in low tones at Sterling's elbow. When my husband saw me approach alone, he laughed, quietly, deliberately, the kind of laugh designed to carry. She came by herself, he said to Sterling, nodding toward the binder under my arm. What is that, her feelings journal? His mother said nothing. She simply watched me with the flat assessment of someone who had already finished the calculation. I watched the far end of the hallway, where the elevator had just opened. Morton walked out. He moved with the same unhurried steadiness he'd had on the train, the cane tapping a slow rhythm on the marble, his posture upright, carrying nothing except a leather portfolio and the particular quality of stillness that belongs to people who have spent so long being listened to that they no longer need to fill silence to command it. My husband watched him approach. His expression settled into something close to pity. That your backup, he said. That's your secret? Sterling glanced at Morton, looked away. We'll have him out before he opens his mouth. Morton reached the courtroom doors and held one open, looking back at me. I walked through. We took our places, my husband and Sterling at the respondents' table. Morton settled into the front row of the gallery, directly behind the partition. Jade and my mother-in-law arranged themselves beside him. Judge Alford took the bench precisely at 9. He was a compact, businesslike man who communicated with his posture that every minute spent on unresolved matters was a minute extracted from him against his will. He reviewed the docket, then looked at my table. Petitioner is self-represented. Yes, Your Honor, with an advisor present. Advisors don't speak in my courtroom, he said flatly. He turned immediately to Sterling, and I watched his posture shift, a nearly imperceptible ease, the way people move when they're in the presence of someone whose company they're certain of. Mr. Holt, walk me through the motion. Sterling was polished and precise. He outlined the will contest, undue influence, cognitive vulnerability, suspicious timing, and then turned to my binder. The petitioner has compiled what she describes as a financial analysis of the respondent's business holdings. Your Honor, the records were obtained by accessing my client's private business documentation without consent and without a court-ordered subpoena. Under established evidentiary doctrine, this material is tainted. We move to suppress it entirely and dismiss the petitioner's financial claims with prejudice. Judge Alford nodded. He had the look of a man delivering a verdict he had already decided on before he sat down. That's a reasonable position, Mr. Holt. He turned to me. You have 60 seconds to tell me why I shouldn't grant this motion and send you on your way. I stood. Your Honor, the records in my binder came from 3 sources. The Delaware Secretary of State's Public Business Registry, accessible to any citizen. Federal Schedule C filings I co-signed as this man's spouse during our marriage, which I'm legally entitled to reference. And a deed transfer pulled from Virginia's public property records. I paused. None of these required a subpoena. Mr. Holt's motion mischaracterizes the origin of every document I've submitted. Sterling didn't hesitate. Your Honor, the petitioner used knowledge of private business operations, gained through the marital relationship, to target specific records. The origin of the search is tainted even if the documents themselves are technically public. Judge Alford was nodding again. I'd like my advisor to address this point, I said. I said advisors don't speak in Your Honor. The voice came from behind the partition, quiet, steady, the voice of someone who had earned the right to interrupt decades before today. The small gate in the partition swung open. Morton walked through it. I watched Judge Alford's face. He had been mid-sentence, his pen stopped, his hand went flat against the desk. For 3 full seconds he did not speak, then he stood. In 11 years on that bench I doubted Judge Alford had stood up for anyone. Justice Calloway. His voice had changed entirely, stripped of its impatience and authority, leaving something that looked very much like a man who had just understood exactly how exposed he was. I had no idea you were in the building today. Sterling turned around. I watched the information reach him in stages, the name, the face, the implications, and I watched his body make a decision. He sat down heavily, one hand gripping the edge of the table. My husband leaned toward him. Sterling, who is that? What's happening? Sterling did not answer. Morton Calloway was a retired federal appellate judge who had served 17 years on the Fourth Circuit before stepping down. In that time he had authored over 300 published opinions, several of which had become foundational precedent in property law proceedings across 11 circuits. He was also the sitting chairman of the Virginia State Bar's Ethics and Disciplinary Committee, the body with authority to investigate and permanently disbar any attorney practicing in the Commonwealth. He had taught evidence law at the University of Virginia School of Law for a decade before his judicial appointment. Sterling Holt had passed the Virginia bar using a textbook Morton had written. And he was now standing on the opposing side of the courtroom floor. If it pleases the court, Morton said, addressing Judge Alford with the calm of someone for whom courtrooms had long ago lost the capacity to impress, I request permission to act as pro hac vice advisor for the petitioner. Judge Alford said yes before Morton had finished the sentence. From the gallery I heard my mother-in-law make a small sharp sound, the sound of a calculation being revised too late. Morton sat beside me and placed his portfolio flat on the table. Mr. Holt, he said pleasantly, please continue with your motion, we're listening very closely. Sterling presented the argument again, more carefully this time, without the theatrical confidence, checking Morton's expression between sentences the way you check the horizon when you think weather is coming. When he finished, he looked at his legal pad. Morton reached into his portfolio, handed me the federal appellate ruling. I submitted it to the bailiff, who carried it up to the bench. Your Honor, I said, this binding precedent establishes that the marital privacy doctrine does not apply to business activity used to conceal assets from a spouse during dissolution proceedings. Every document in my binder falls within that exception. Mr. Holt's motion has no legal foundation. Judge Alford read the document. I saw the moment he understood. He looked once at Morton, then he set the ruling down. Motion to suppress is denied. The petitioner's binder is admitted in full. My mother-in-law audibly exhaled. My husband turned to Sterling. Sterling was studying the table. Morton requested that my husband be placed under oath to address the discrepancy between his sworn financial affidavit and the Cedar Line property holdings transfer. Judge Alford ordered it without hesitation. My husband walked to the witness stand. His jaw was set. He had the look of a man who had been promised a simple, painless outcome and was beginning to understand that the promise was not going to hold. I worked through the binder methodically, the deed transfer, the LLC registration, the gap between declared and actual business revenue across 3 tax years. My husband answered in short, guarded sentences: business structuring, standard asset protection, nothing unusual for a contractor his size. Then I asked about the cabin. The Shenandoah property was transferred to Cedar Line Property Holdings on March 14th. Your financial affidavit submitted to this court lists no property held under that entity. Can you explain the discrepancy? Cedar Line is a separate business structure, he said. Any business attorney would recommend. Did you disclose the transfer to me? Silence. Did you disclose it to this court in your affidavit? Judge Alford, answer the question. No, husband said, flat and quiet the way a door sounds closing on an empty room. I turned to the next section. Your affidavit claims limited liquid assets. Can you describe the origin of the funds used to purchase the vehicle registered in Jade's name 6 weeks ago? The one you co-signed for, according to the dealer financing agreement I obtained through public record? My husband's hands tightened on the railing. That was a personal matter. The funds came from your business operating account, I said. The same account you described as barely sufficient to cover monthly overhead. I set the bank summary in front of him. Would you like to revise your testimony? Something in him broke open then, not loudly but completely. The way a structure gives way, not with a crash but with a sound like settling, like things finally finding the level they should have been at all along. I built that company, he said. The restraint in his voice was failing. Everything we came from what I created. You filed paperwork and went to appraisals and told yourself that made you equal to what I did. It didn't. The cabin was mine. The business was mine. Everything was mine. I paid the mortgage for the first 4 years, I said evenly. While your business was operating at a net loss, I have the joint tax returns. You don't understand what it takes to build something real. I value businesses for a living, I said. I understood exactly what this one was worth, including the part where you transferred $280,000 in real property to a shell LLC and told a court under oath that you had nothing to offer me. Judge Alford set his pen down. He looked at my husband for a long moment, then he looked at Sterling. Sterling was examining his legal pad with the concentration of a man who has decided he is no longer present. Mr. Holt, Judge Alford said quietly, your client has just contradicted his sworn affidavit on the record. The judge voided the will contest. He admitted the estate documents and confirmed the distribution as written. He froze my husband's business accounts pending a formal accounting. He ordered Cedar Line Property Holdings dissolved and the cabin returned to the marital estate. He awarded me the full value of the watch collection. He referred the affidavit discrepancies to the Commonwealth's attorney. My mother-in-law rose from the gallery. She did not scream. She pointed at me with one steady finger and said, in a voice that was very controlled and very cold, "This is not over." Judge Alford looked at her. "One more word and I hold you in contempt." He did not raise his voice, she sat. In the hallway afterward, Jade was already on her phone. She ended the call when she saw me coming. I stopped in front of her. I looked at my mother's locket at her throat. My mother gave that to me the last morning I saw her conscious, I said. There's a photograph inside of us together, 6 weeks before she died. Jade's expression changed. She wasn't who I'd spent months imagining. She was 23 years old and had made the mistake of trusting a man who was accustomed to taking things. I could see her understanding the mistake in real time. She reached up and unclasped the chain. She placed the locket in my open palm without making eye contact. I didn't know, she said. I know you didn't, I said. I closed my hand around the gold and walked toward the exit. 2 uniformed officers were crossing the lobby toward my husband, who had emerged from the courtroom behind me looking like someone had slowly let the air out of him. The larceny report I'd filed the previous night had moved faster than I anticipated, once my attorney flagged it as part of the ongoing fraud referral. My husband saw the officers. He looked at Sterling, who was on his phone looking in the opposite direction. He looked at his mother at the bottom of the steps, who turned her face away. I watched the officers reach him. I watched his expression when he finally understood that there was no one left to call. I did not feel what I had expected to feel, not the hot, sharp satisfaction I had been bracing for, just a very quiet sense of arithmetic. This was the sum of his choices, everything carried and balanced, the final figure on the last line of the page. Morton was waiting near the front steps. The morning light was coming in at a low angle, and the stone building behind him looked the way old buildings look when the weather is finally clearing. He reached into his portfolio and handed me an envelope. The Calloway Group has been looking to bring a licensed appraiser in-house, he said. Someone who can serve as an expert witness in high-stakes estate litigation and build a formal valuation practice. I sent them your credentialing information last night. They confirmed their interest this morning. I opened the envelope. The firm's letterhead was one I recognized, one of the top estate litigation support practices in the Mid-Atlantic. The offer outlined a senior consultant position with a structured path to partnership, a compensation package that made my current salary look like a rough draft, and a start date in 60 days. Morton, I said, there wasn't anything else. You caught an error on a train that 3 experienced professionals had missed, he said simply. That tells me everything about how you work. He extended his hand. They'll expect your call by Friday. I shook it, thank you, for more than the job. He smiled, that careful, knowing expression, and made his way down the steps to where a town car was waiting at the curb. That was 4 months ago. I keep my mother's locket in the front pocket of my work bag now, where I can feel it whenever I reach for a pen. My husband pled guilty to 1 count of financial fraud and 1 count of theft of personal property. He lost his contractor's license. His mother sold her house to cover his legal costs. Sterling Holt is currently under a formal bar investigation for misrepresenting public records to a sitting judge. Judge Alford retired quietly the month following our hearing. I moved to Alexandria in September. My apartment faces east, and the mornings here are different from anything I expected, quieter and entirely mine. What I think about, when I let myself sit with it, is how gradual it was. Not a single moment where everything went wrong, but years of small accommodations, making myself a little smaller, a little quieter, a little more willing to accept his version of what things were worth. It happens that way. You don't notice the erosion until you look at the shape of yourself and barely recognize the outline. I had that watch collection appraised properly last month. Documented, defensible, court admissible. The lead piece turned out to be a 19th century American railroad pocket watch in exceptional original condition, worth considerably more than my husband had ever bothered to find out. He had never asked. He had looked at something valuable every day for years and never once wondered what it was actually worth. That was the real mistake, not the LLC, not the locket, not the false affidavit. The real mistake was looking at a woman who had spent her entire career learning to see the true value of things, deciding she didn't know what she was worth. I balanced the books. The numbers came out right, they always do in the end.